Hi, I'm Tanya Hendrix, Huntsville estate planning lawyer. Wills versus trusts in Alabama. Which one do you need? I get that question a lot. Do I need a will? Do I need a trust? That is a frequently asked question of people who walk in my door here or I just see out and about at Huntsville estate planning lawyer. So if you live in Alabama, and if you're starting to think about estate planning, you've probably asked yourself one question. Do I need a will or do I need a trust or do I need both? The truth is, no one size fits all. There's not a one size fits all answer. The right choice depends on your family, your assets, your goals, your wishes as to your estate plan, and what you leave to your loved ones after your death. In this video, I'm going to break down the differences between wills and trusts in Alabama so you can make an informed decision to protect those who you love. Or probably you want to come in and talk to an estate planning attorney like me to determine what's best for your situation. But this is going to give you just some basic information. So first of all, what is a will? A last will and testament is a legal document. It says what should happen to your property, to your assets after your death. It also lets you name a guardian if you have minor children. You also choose an executor, or what we call a personal representative. This is the person who carries out your wishes. In Alabama, a will must be signed by you and witnessed by two people to be a valid will. Most wills, so when you come to my office, Tanya Hendrix at Huntsville Estate Planning Lawyer, we're going to include a self-proving affidavit, which makes things a lot easier when you pass away to get that will probated and through the process. So a will is often the simplest and most affordable estate planning tool. It works well for many families, especially those with kind of a straightforward assets and clear wishes. I want to caution here because a lot of people say, oh, I have a simple estate, and then they start talking about their blended family, or they've got minor children, or they got a house in another state or property in another state. Those are not simple issues. A will works great when it's straightforward, it's very clear, there's no complicated issues. But there's one thing every Alabama resident should know about and understand about wills, and this is a very common misconception, is that a will does not avoid probate. Depending on how certain assets are titled at your death, your family, if all you have is a will, your family or loved ones may still have to go through the probate process, even if you have a will. Again, a will does not prevent you from going through the probate process. So what is a trust? A trust is also a legal document. It's a legal arrangement where you place your assets into the trust and you're naming a trustee to manage them. Most people start with a revocable living trust, which means you can change or cancel it, revoke it at any time. You can property to it, you can take property out as long as you're alive. You can even serve as your own trustee initially. Now, if you become incapacitated upon your death, you have to have someone else stepping in, but you are the initial trustee of a revocable living trust. So you can manage your assets. So the trust can manage your assets during your lifetime. So if you become incapacitated, your successor trustee can immediately step in and manage things and make sure you're taken care of while you're incapacitated. Now, the biggest advantage of a trust is that the assets held inside that trust do not have to go through probate. When you pass away, your successor trustee can distribute your assets immediately, directly to the beneficiaries, according to the instructions you left within the trust. And this saves and can save your family, your loved ones, significant time, money, and stress. A trust also offers privacy. A will becomes part of a public record. When it's in probate court, it's a public record. So anyone can step into probate court and ask to see your estate file and see your will, who left things to, all those things. So a trust generally stays private, so the details of who inherits from you is not open to the public for anyone to see. Now, probate is a process that is used to validate a will. It pays off debts, it transfers property to heirs. In Alabama, a probate is handled at the county level, and the process can take several months, a minimum 6 months, but most of the time longer than that. Depending on how complicated the estate is, if you got creditors, if you've got people fighting over things, if it takes a long time for property to sell. So the probate also comes with court costs, attorney's fees. Depending on how your will is prepared, there could be some other fees associated. And all of this is paid out of the estate. So what you're leaving to your family, it's estate administrative costs, attorney's fees, all that comes off the top. That's before your family receives anything. For some families, the timeline and costs are manageable, it's doable, it's not a big deal. For others, especially those who own property in more than one state or who want to keep things simple for the loved ones, avoiding probate is a top priority. Now, side note, when you own property in another state, it is very likely your family will open an estate here in Alabama and in the other states called an ancillary estate. So not only if you have property in another state, not only could you have one estate open here in Alabama, but you will probably have to open one in the other state in order to transfer that property. All right. So avoiding probate is often a key factor or deciding factor when choosing between a will and a trust. Oftentimes people come to my office and they say, I want to avoid probate. And so that really, we start talking about trust. So the key differences between wills and trust. So probate, your will must go through probate. Depending on how assets are titled, a will does not keep you out of probate. A properly funded trust can avoid probate entirely. And I want to stress properly funded. If you have not funded your trust, or if at the time of your death, it's not properly funded, your family may still go through probate. Also, privacy. Wills become public record. Trusts are generally kept private. The cost to set up is also a key difference. So the initial cost of setting up just a will-based plan is going to be significantly less expensive than a trust-based plan. However, your family, that's on the front end. So your family, your loved ones, if you do just a will-based plan and it has to go through probate, they'll be paying that fee, those additional fees at that time. And it's probably going to be more expensive than had you done a trust to begin with. Okay. Also, a key difference is control of your life. So a trust can help manage your affairs if you become incapacitated without the need for a court-appointed guardian or conservator. A will only takes effect after your death. And then for guardianship, if you have minor children, guardianships for minor children are provided for in a will. So that's taken care of in the last will and testament. So which one do you need? A will may be the right fit if you have a smaller estate, you have no complications, you don't own real estate in multiple places or multiple states, and you're comfortable with your family going through the probate process. A will is also required if you have minor children, because that's where we have to name the guardians of your minor children. A trust may be the better choice if you own a home or other property in another state, you want to avoid probate, you value privacy, or you want a plan in place in case you become unable to manage your own affairs. Also, if you have minor children, it's good to have a trust because the trust can manage those assets until a certain time in the future when you would want them to get those monies. It also gives you a little more control and management over how that gets distributed to them. So, can you have both a trust and a will? Yes. And in fact, all estate planning packages that I prepare at Tanya Hendrix, Huntsville Estate Planning Attorney, if we do a trust plan, so if we do a plan that has a trust in it, we're going to do a will. It's called a pour over will, P-O-U-R, pour. Think about pour over. Because if you forget to add some property to your trust, there's something out there that the trust isn't covering, or you haven't made it named as a payable on death beneficiary, then we need that will there as a safety net. So it's a safety net. So it can catch all those assets not in your trust or not distributed by beneficiary designation and pour it over into your trust to be distributed through the trust. So it's a backup plan. But again, Every estate planning package that I prepare is, if it has a trust, it will also have a will. I will not do a trust without that pour of a will. Now, every family is different. There's no single right answer for every person in Alabama. The right plan depends on the size of your estate, whether you own real estate in other states, your family situation, your family dynamics, your goals for privacy and control, and what are your overall goals and wishes for your estate. So that is why estate planning should never be a copy and paste process. There's just so many nuances to it. Don't copy and paste. At Huntsville Estate Planning Lawyer, we take the time to understand your family and your wishes before we recommend a plan, because we believe in people first, not just paperwork. So will versus trust, which one is right for me? Choosing between a will and a trust does not have to be confusing. I'll be happy to walk you through your options and build a plan that fits your family and your goals. Whether you need a simple will, a full trust-based plan, or both, I'll be happy to help you with figuring that out and deciding what's going to be best to protect who matters most. So call me today, Tanya Hendrix, Huntsville Estate Planning Lawyer at 256-361-1221, and we'll be glad to schedule a consultation with you to talk through your options. Now, you cannot be there for everything life brings, but your plan can be. Tanya Hendrix, Huntsville Estate Planning Lawyer.